So more gun rights organizations have jumped into the Duncan v. Bonta California magazine ban case in an effort to eliminate this magazine ban in the state. So let's talk about this. But real quick before we jump into this video, if you believe California's ban on so-called large capacity magazines is unconstitutional, go ahead and hit that like button and subscribe. Also want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn the skills and techniques they'll need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit the website linked down below. And thank you again, SDI, for sponsoring this video. So like I said in the intro, in this video, we're going to be talking about the Duncan v. Bonta California magazine ban case. Currently, we are waiting to see what the Ninth Circuit decides to do with this case, Duncan v. Bonta. The parties have already submitted their supplemental briefs to the Ninth Circuit per the Ninth Circuit's request. This is currently at the Ninth Circuit en banc level. The state of California has argued to the Ninth Circuit that they should vacate Judge Benitez's ruling and to send this case back down to the district court for review. The plaintiffs in this case actually want the Ninth Circuit to review this case, to keep it at the Ninth Circuit level, and to finally resolve this issue. However, we just had some additional movement in this case where various 2A organizations, including GOA, have jumped into this case, have filed an amicus brief arguing with the plaintiffs in this case that the Ninth Circuit finally needs to resolve this issue. In the Duncan case, these new groups have filed an amicus brief arguing that it's finally time for the Ninth Circuit to do the right thing, to strike down these unconstitutional laws in the state of California, and to actually rule on this magazine ban case. Now, for those not aware of what Duncan v. Bonta involves, let me explain real quick. Duncan v. Bonta involves the possession and purchase of so-called large capacity magazines in the state of California. California Penal Code Section 32310 bans the buying, selling, possession, etc. of magazines that hold more than 10 rounds. This law was challenged, and a district court judge, Roger T. Benitez, or St. Benitez, issued a ruling and found that that law was indeed a violation of the Second Amendment. This led to what is known as Freedom Week in the state of California, where during a single week period of time, millions of magazines were purchased and brought into the state of California and are currently still in lawful possession of various citizens within the state of California. After this week period of time, the ruling by Judge Benitez said those in lawful possession of those Freedom Week magazines could maintain them without fear of prosecution. The enforcement of that law against the possession of magazines was put on hold until the final determination in this case. Also, he then placed a stay on his own judgment. Well, the state of California didn't like that they lost at the district court level, so they appealed the decision up to the Ninth Circuit. A 3-judge panel in the Ninth Circuit reviewed the decision, and they reviewed the decision of Judge Benitez, and ultimately they agreed with him. Well, after the state of California lost once again, they decided to seek a rehearing en banc. In coming to its decision, the en banc panel in the Ninth Circuit rejected text, history, and tradition as a test that should be used when looking at these types of cases. Instead, they used the traditional approach of the Ninth Circuit, which is the two-step approach and a balancing of interest test. The decision by the en banc panel was then appealed up to the Supreme Court because, again, the en banc panel did uphold this law in the state of California. The Duncan case was then put on hold until the Supreme Court ruled in the New York State Rifle and Pistol Association v. Bruin case. Well, as many of you know, the Supreme Court recently ruled in Bruin, and they affirmed that text as informed by history and tradition is the appropriate test when you look at these types of Second Amendment cases, and also they expressly rejected the two-step approach. The Supreme Court then granted, vacated, and remanded the Duncan case back down to the Ninth Circuit en banc panel to rule in light of their decision in Bruin. The Ninth Circuit recently requested additional briefs from the parties asking what they believe the Ninth Circuit should actually do in this case now that Bruin has been ruled on. Of course, again, the state of California requested a complete remand of this case, while the plaintiffs simply asked for the Ninth Circuit to do their job and to review this case per what the Supreme Court said. But in response to this and this signal by the Ninth Circuit indicating that they're likely going to vacate and remand the Duncan case back down to Judge Benitez, GOA and various other 2A organizations have joined together and have filed an amicus brief up to the Ninth Circuit en banc panel. In their amicus brief, GOA hits on the fact that before Bruin, the Supreme Court warned lower courts like the Ninth Circuit that defying the Heller and McDonald decision is a bad idea, but courts like the Ninth Circuit continue to do that. First, they state in their brief that there are many lessons that the lower courts must take from the Bruin decision, but the most fundamental is its unequivocal prohibition of the use of the two-step approach. The Ninth Circuit did not invent the two-step approach, but it was one of the few circuit courts that relied heavily on that test to uphold these various Second Amendment violations. GOA in their brief then walks through all the major Second Amendment cases that have made their way through the Ninth Circuit, many of which have already been remanded by the Ninth Circuit. GOA states in their brief, the amici urge that the en banc panel apply Bruin and rule on the challenge without remand to the district court. The present case is already before an en banc panel. indicating the significance of this issue involved. With the facts not in dispute, it is a purely legal matter to consider whether California's magazine ban at issue here is consistent with the Second Amendment, applying the test laid out in Bruin. Deciding this case now will promote judicial efficacy and provide guidance to the lower courts and other panels of this court in handling the cases identified, as well as others that will come. Here, GOA is pointing to the fact that this is an important case that's already at the highest level of review outside of going back to the Supreme Court. The Ninth Circuit has the opportunity to review this case and also to provide guidance for all the other cases currently pending and future cases that might pop up. If they decide not to rule on this case, we will likely have a bunch of lower courts, district courts ruling however they want because they don't have guidance outside of the Supreme Court, which they should follow guidance of the Supreme Court. But what we've seen, sometimes these district courts will just not apply that correctly, and instead they will just apply it however they want. They will narrow it from below, and then it takes the circuit courts to kind of correct all those errors. But here we can bypass all of that if the Ninth Circuit actually looks at this case. Then GOA concludes in the amicus brief with a strong warning to the Ninth Circuit. They point to the Caetano case where a concurrence from Justice Alito and Justice Thomas openly called out Massachusetts and those courts for defiance of the decisions in Heller. In that case, Alito stated, although the Supreme Judicial Court professed to apply Heller, each step of its analysis defied Heller's reasoning. The lower court's ill treatment of Heller cannot stand. He stated in that opinion that the reasoning used by the Massachusetts courts posed a grave threat to the fundamental right of self-defense. GOA goes on to state that accusing a lower court of intentional defiance of Supreme Court precedent is strong stuff, and hopefully it will not be needed in the aftermath of Bruin because the Ninth Circuit openly defies or decides to openly defy the Supreme Court's decision in Bruin. So GOA is pointing out that the Ninth Circuit is at a crossroads right now. They can faithfully apply the Bruin decision and also faithfully apply the Second Amendment, or they can openly defy the Supreme Court, which GOA is promising will result in a decision similar to Caetano, where the Supreme Court will say, lower courts, we told you what to do. You've once again openly defied our decisions, so we're going to take this in our own hands and decide appropriately and accordingly. And that's what happened in Caetano. And so the threat is if the Ninth Circuit and these other lower courts continue to refuse the Supreme Court's decisions, eventually the Supreme Court will just rule on all these issues on their own, which I would suspect that the Ninth Circuit and the state of California and New York and New Jersey and all these liberal-leaning or left-leaning circuit courts and states, they really don't want this current makeup of the Supreme Court to rule on these issues. And that's kind of what they're facing if they continue to defy the Supreme Court's ruling in Bruin. Now, they may have some hope right now that they can stall these out long enough and maybe the makeup of the Supreme Court will change. That's always an option. Maybe they're going to go down that road. It seems like that is kind of what they're leaning on, and that's what their hope is right now. But again, that's not always the best bet because we even saw in Caetano, even without the current makeup of this court, the Supreme Court still ruled against the circuit courts, against the state of Massachusetts because they were openly defying the Supreme Court. The Supreme Court, in whatever makeup it is, does not like when lower courts openly defy their rulings. Now, in my opinion, I still think that the Ninth Circuit is likely going to punt this case. I think right now their only strategy and tactic is try to stall these cases out for as long as possible. That is definitely not the best case scenario because it just simply drags these cases out even longer. But even if it's remanded back down to the district court, it will go back in the hands of Judge Benitez. And as we've seen, Judge Benitez has already ruled twice on this very case, has found twice that this magazine ban is unconstitutional, and the odds are that he will do that once again. So that is where the California magazine ban currently stands. I appreciate more organizations and groups jumping into this case to try to get the Ninth Circuit to actually do their job and to rule on this case. We will see how this plays out. If we get any more information, I will let you all know. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in the Tap It To It news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.